Nesara Gesara, Part 5. The Supreme Court or Judicial Activist. Judicial Review Unconstitutional. Who watches the watchers? Alright, Part 5 of Nesara Gesara. Okay, I am going to begin with this quote from Thomas Jefferson in 1823. At the establishment of our Constitution, the judiciary bodies were supposed to be the most helpless and harmless members of the government. Experience, however, soon showed in what way they were to become the most dangerous, that the insufficiency of the means provided for their removal gave them a freehold and irresponsibility in office, that their decisions, seeming to concern individual suitors only, pass silent and unheeded by the public at large, that these decisions nevertheless became law by precedent, sapping by little and little the foundations of the Constitution, and working its change by construction before anyone has perceived that that invisible and helpless worm has been busily employed in consuming its substance. In truth, man is not made to be trusted for life, if secured against all liability and to account. Judicial review is the process where the Supreme Court decides if a law is constitutional or unconstitutional. Does the Constitution grant the Supreme Court this power? I believe it does not, but let's take a look at the powers of the Supreme Court granted by the Constitution. Article 3, Section 2 lists the powers of the Supreme Court. Section 2. The judicial power shall extend to all cases in law and equity arising under this Constitution, the laws of the United States, and treaties made, or which shall be made under their authority. To all cases affecting ambassadors, other public ministers, and consuls, to cases of admiralty, and maritime jurisdiction, to controversies to which the United States shall be a party, to controversies between two or more states, between a state and citizen of another state, between citizens of different states, between citizens of the same state claiming lands under grants of different states, and between a state or the citizen thereof and foreign states, citizens, or subjects. In all cases affecting ambassadors, other public ministers, and consuls, and those in which a state shall be party, the Supreme Court shall have original jurisdiction. In all other cases before mentioned, the Supreme Court shall have an appellate jurisdiction, both as to law and fact, with such exceptions and under such regulations as the Congress shall make. After my analysis, I would say no, the Supreme Court does not have the power of judicial review. In 1974, when the Supreme Court declared an act of Congress to be unconstitutional, was the first time that the Supreme Court said anything about whether a law is constitutional or unconstitutional. But it went largely unnoticed until the landmark case of Marbury versus Madison in 1803. Marbury versus Madison will be another video later on that I'll go more into depth. but Marbury is significant less for the issue that it settled between Marbury and Madison than for the fact that Chief Justice John Marshall used Marbury to provide a rationale for judicial review. Since then, the idea that the Supreme Court should be the sole and final arbiter of constitutionality issues has become so ingrained that most people incorrectly believe that the Constitution delegated this power to the federal judiciary. This is the whole situation with the Supreme Court having constitutionality or powers to determine constitutionality is a classic example of repeat until they believe. They've ingrained this so much in your head that you just basically believe it. And the Constitution does not give this power to the Supreme Court. I believe that under the 10th Amendment, this is a reserved power of the states. And, I know what you're thinking. Your belief is now then, who will determine if the laws are unconstitutional? Okay, so first let's make something clear. It is not a power granted to the Supreme Court. Okay, let me start this over. The judicial review is not a power granted to the Supreme Court by the Constitution. When the Supreme Court exercises judicial review, it is acting unconstitutionally. It is a huge conflict of interest. The federal government is judging the constitutionality of its own laws. Once again, it's a classic case of the fox guarding the henhouse. The Constitution's checks and balances were designed to prevent any one branch of government, legislative, executive, or judicial, from becoming too powerful and running roughshod over the other branches. There is no such system of checks and balances to protect the states and the people when multiple branches of government acting in concert erode and destroy the rights and powers of the states and the people. Even if the Supreme Court could be counted on to keep the executive and legislative branches from violating the Constitution, who is watching the Supreme Court and will prevent the judicial branch from acting unconstitutionally? Unless you believe that the Supreme Court is infallible, and we've seen that the Supreme Court isn't, then allowing the Supreme Court to be the sole arbiter of the constitutionality issues is obviously flawed. Justices Justices are appointed and not elected, and may only be removed for bad behavior, which has happened in the distant past, but today, more than likely it's not going to happen. If the court upholds unconstitutional laws, there is no recourse available. We, the people, cannot simply vote them out to correct the situation. It is the Constitution, not the Supreme Court, which is the supreme law of the land. Even the Supreme Court should be accountable for overstepping constitutional limits on federal power. Judicial review turns the Constitution on its head. The judiciary was created as the weakest branch, controlled by both the legislative and executive branches. Judicial review makes the judiciary master of both the legislative and executive, telling them both what they may and may not do. The people and the states have little control over the makeup of the Supreme Court. Given that it was the people and the states which established the Constitution, it is the states who should settle issues of constitutionality. The Constitution is a set of rules made by the states as to how the government should act. The judicial review paradigm allows the government to make its own rules, with no say by the original rule makers, the states. The Constitution was created by the states, and any questions as to the meaning of the Constitution is rightly settled by the states. Since the power of judicial review is not expressly granted to the Supreme Court by the Constitution, this power, per the 10th Amendment, is reserved to the states respectively, or to the people. Thomas Jefferson also wrote, "The Constitution, on its hypothesis, is a mere thing of wax in the hands of the judiciary, which they may twist and shape into any form they please." Sam Irvine. A judicial activist is a judge who interprets the Constitution to mean what it would have said if he, instead of the Founding Fathers, had written it. Samuel Adams. How strangely will the tools of a tyrant pervert the plain meaning of words. Justice Antoninus Scalia. Day by day, case by case, the court is busy redesigning a constitution for a nation I do not recognize. And that is what I'm going to leave you to ponder on. Judicial review. I believe the states and the people should be deciding what is constitutional, what is unconstitutional, because the Supreme Court does not have the power to do so. So, those are my parts on what this whole returning back to constitutional law means. And remember also that the United States is a republic, and the Constitution, I believe I read it in section 4, says that the United States is a republic form of government. So, you guys have a good one. I hope you enjoyed this, and bye.